General, let's just suppose with me hypothetically for the moment that the court read the act to require notice and a hearing. I assume everybody has notice now. Here we are. What would that hearing look like?
I would point to what the court has said in Vermont Yankee, which this court is very reluctant to dictate procedures to even federal agencies. And here the court would be dictating, or a court would be dictating procedures to the president. I think they rely heavily on Loudermill. Obviously, we dispute that there's any notice and hearing requirement, but Loudermill requires only very minimal, flexible procedures.
Would that be calling Ms. Cook into the Roosevelt room, sitting across a conference table, listening for I don't know how long, how much evidence is a lawyer required, and then making a decision? Could that suffice, you think? Or what would be required?
It would probably be if the court were to conclude that, it would have to be entirely dependent on the executive to decide. And that's what the case law indicates. Certainly, I think the question points out a great weakness in their argument, which is that the word cause does not include notice in a hearing on its face. Congress knows how to provide notice in a hearing. It did so in the NLRA 1 month before it reenacted the for-cause restriction here in 1935. And because it's not there, the court has nothing to provide guidance on that point. And if the court were to conclude that, it would be up to the executive's discretion.
Just a meeting across a conference table finished with you're fired? I mean,
all Loudermill says is that you have to be told of what the basis is of the allegations against you and give a chance to tell your side of the story. We believe that was provided in the 5-day window between the Truth Social Post and the removal letter.
And then you mentioned on remedy that there's no such thing as a preliminary injunction for mandamus. And I just wanted to hear you a little bit more on that. You mentioned Judge Friendly. Please, thoughts.
So the contention in the amicus briefs is that you could rely on Delgado to sort of bypass the holding of Sauer and say that mandamus can provide essentially the same relief as a preliminary injunction. I guess the argument would be you'd have to mandamus everybody, so all the members of the other members of the board to treat her as if she's still a governor, all the staff to treat them as if they were still a governor, because Delgado held where there's the city clerk who can't decide who is validly elected city commissioner, the court held you could mandamus that clerk to recognize the de facto officer in the interim. And that doesn't work for a couple of reasons. First of all, this is a preliminary injunction. Mandamus would have to be a final judgment, and that's what Judge Friendly said. There is no preliminary mandamus. That's the starkest of solecisms.
Do I understand you, General, going